Hello, I'm glad to invite you all. All the attendees are requested to give their introduction in the chat box. Hello, Mahaprasad. I'm glad to have you in this webinar. So it's 6:04. So can we start the webinar
Yeah,
now?
sure. Please.
Okay. Hello everyone. The sir is Saransh. Our speaker of the day is Saransh Chaturvedi sir. He is the advocate in the Allahabad High Court, the Lucknow bench. He has graduated from a most reputed university, that is Varanasi Hindu University, well known as the BHU. And sir is having his masters in law from IIT Kharagpur. He is specialized in IP law. So we welcome you, sir, to the webinar on trademark prosecution and selection.
Thank you very much.
Uh, Thank you, sir. Nowadays, in the companies, and there is very small and big farms and companies, startups. IP law is playing a very vital role nowadays, because trademark is the essence of the company. Since if the trademark has been infringed or the trademark is not selected in a proper manner, the company is going to face a lot of loss. The consumers will be misguided by other fake and some copies products, like when we see any products in our market, a whale brand like Woodland or Peter in England, we can see many of companies are also copying their products and just selling in a very low price. Though we can go to the original material, original products, the companies are facing a lot of difficulties. Even there are very a lot number of startups that are coming up in the few years, and will be coming up in the next few years also, in many years, to be honest. Copyright, trademark, mostly intellectual property is going to play a very vital role. So today we will discuss that how the trademark will be selected by the companies, how the trademark will be uh, put, like registered, and then if a registered trademark has been infringed, how the prosecution, how the court will be helping those companies to deal with it. So I welcome sir to tell our attendees about the prosecution and the selection of trademark. Welcome you, sir.
Thank you very much. Thank you very much. Let me share my screen.
Yes, sir.
So is it visible?
Absolutely, sir.
Yeah. So thank you very much for your introduction and even for the introduction of this topic. Trademark is as Neelam said, trademark is a very broad topic. Trademark has variety of other aspects to be dealt with. So trademark selection and trademark prosecution is one of those variety of topics that can be dealt under trademark. Like we have trademark opposition, trademark infringement, and even trademark registration. So different type of trademarks are there. So in these different types of trademarks, I will be specifically dealing with the trademark selection and prosecution. Now, talking about this topic is very important because trademark selection is not a legal topic. It is a topic which is primarily being held or which is primarily being thought by everyone. Whosoever is starting a business, even without having a law background, will try to think of having that type of a trademark, which have some value and which have some importance in that, right? So trademark selection becomes a very important part in the trademark aspects, or in comparison to all the aspects. All aspects are important, but if you are selecting a very well trademark, then your variety of things like opposition, infringement can be cut out because you are selecting a very good trademark, right? So selection of a trademark is a very important part. Well, I don't know the variety of attendees as whether they are like I have seen one is a high court advocate, but I don't know other people. So what I will be dealing is I will be first of all telling you what is the general framework and what is the general understanding of trademark, right? And then probably after general understanding of trademark, I will be dealing with the selection of trademark. So let us start with this trademark. What is trade? trademark first of all. Now, in section 2ZB of trademarks at 1999, the trademark definition is being given. So if I start a business, let's say I start a business of a restaurant business tomorrow, and that restaurant business is based in Delhi. So first of all, what will I think is having that type of a name of that restaurant, so that it could point out, or so that it could be helpful for me, so that I can distinguish itself or distinguish myself in that market area. That is the first point which every businessman will think of. So that is what called as trademark selection. We will select some trademark, we will think of any mark, so that I can distinguish myself from other people in the market. So if I am starting a restaurant, a hotel, or a hotel, so I will be choosing a mark which I can use that mark, so that I can distinguish myself in the market. So that the similar definition has been provided in the Trademark Act 1999, which says that it is capable of being represented graphically and capable of distinguishing the goods and services of one person. So trademark means a mark. I have made this mark in a very important manner, because this mark is the main thing which has to be selected, and which has to be protected, and which has to be prosecuted, right? So when you are trying to deal with the trademark, you are selecting a mark, as in definition section 2 clause M is given. It can be anything: brand, heading, label, ticket, name, signature, letter, numeral, shape of goods. So tomorrow, if I start a business of let's say hotel, which I said in Delhi, I can put my name Saransh as a part of a mark, and I can also go to the trademark office for registration of my name Saransh as a part of a business, so that I can use that name of Saransh in terms of having different other in terms of distinguishing myself in the market, right? So I will be using that Saransh name for distinguishing, for even creating a goodwill. As you for example, McDonald's, right? McDonald's, Reliance, these are the names that is primarily known to all of us. Why this is so important is because these names have a goodwill in that. So trademark, why you select a trademark is because you have to distinguish, first of all. Secondly, you have to have a right onto that mark. You will be having some right, which says a right which we will be discussing afterwards. You will want to create a goodwill in the market, right? The goodwill is the most important part, which is always associated with your trademark, right? So you have will be creating a goodwill in the market, and most importantly, it helps, that trademark helps you in identifying the quality and standard of goods, like McDonald's, right? Whenever you will hear the word McDonald, undoubtedly what you will see, that, oh, that kind of a burger is there. That trademark always gives you the identification of the quality of the goods, or the standards of the good, right? Reliance Industries, right? So any you are going to Reliance petrol pump, so whenever you will see Reliance petrol pump, that trademark will help you to identify the quality of that product and good. So in general, trademark, you are choosing a mark for yourself, so that you can represent yourself, or you can distinguish yourself from other goods and services in the market. And you can choose any mark, that is heading, label, ticket, name, signature, any mark, right? For the purpose of your business and your services, right? So these are the examples of trademark: Apple, Mercedes, Microsoft, Vodafone, Walmart. Before that, you have to understand, let's see, this is an example of Walmart. So it is saying save money, live better. So when you are applying for a trademark, when you are applying for in a trademark registry, your registration will also consist of Walmart, plus your registration will also consist of the tagline that is considered with the Walmart, as well as this logo, right? We will discuss it, what are the different types of trademark. But you have to understand the taglines are also considered as in the trademark. So McDonald, I am loving it, it's in the trademark. Nike, just do it, it's in the trademark. So you have to understand all the taglines are also consisted in the trademark, right? So how important trademark can be? IP evaluation is one of the important subject that is dealt in the intellectual property studies, whereby we deal in that subject the value of the IP that is held by you, right? So how the value of trademark can be ascertained? So you can understand that this is the Forbes list of all the brand values that is that is there. So Apple has a brand value of $241.2 billion, right? Google has a brand value of $207.5 billion. So it's not the trademark value, but you can assume by this brand value, that small icon of Apple, have that small bite and apple that we saw in the previous slides, has that level of brand value to represent a company of $241.2 billion, right? So that is the importance of a trademark. That importance of a trademark has to be ascertained in terms of the brand value of a company or a brand value of a business. And that is why the trademark has to be selected, as well as has to be protected to save this brand value. Imagine tomorrow if Apple doesn't have that brand value, or that if Apple doesn't have that small Apple icon, what will happen to the brand value? Undoubtedly, various people used to buy the Apple only because of that icon, right? So that icon has that importance, that creates a brand value. But here, one thing very important one has to understand is that trademark is not equivalent to brand value. See, there are various articles where trademark is used synonymous to brand value. Brand is different and trademark is different. Brand represent the reputation of a company, but trademark represent the reputation of a company in a legal sense. So never use brand and trademark in a synonymous manner. You have to use those both brand and trademark in a different perspective. For a reputation, it's a brand is a big entity, or trademark is a part of a brand. So if a brand is represented legally in for ascertaining your reputation to the consumer, that is called as brand in terms of trademark. But don't use brand and trademark synonymously. We have Indian trademark office. The head office is in Mumbai, the branch office is in Ahmedabad, Chennai, Delhi, Kolkata. So what are the rights of trademark holder? Undoubtedly, when you are having a trademark, you have the exclusive right to use in relation to your goods and services, right? You have to you have the right to seek statutory remedy against infringement. That is what naturally you have all the rights, right? You have a right to assign and you have to right to license. Here you have to make yourself very much clear that there is a difference between what is known as assignee and what is known as licensee. When you are talking about assignee, you are trying to give your license, you are trying to, sorry, not a license, you are trying to give your right to the person you are assigning, right? And licensing, you are not trying to give your right to the person, but you are only trying to give a part of your right. You are retaining all the right, but you are only giving the part to use that right, to use the trademark. I will give you an example, right? Franchisee. In a franchisee, when we buy a franchisee, that name of the company is also given to the person who took the franchise, right? So that is what called as licensing is there. The right of that trademark is retained to the main person. But when you are assigning your right to somebody, you are forfeiting the right, you are forfeiting your ownership even to that extent. So if I am having a trademark, I have a trademark of Saransh for a hotel, I can license to the person whosoever is taking my franchisee, or rather I can go for assigning, or rather in assigning I will be giving my ownership to that, right? So you have all these, there are varieties of right, but these are the most important rights about license, remedies, exclusive right, and assigning, right? So whatever you can do with the property, almost all right are there with you for the trademark, right? So goods and services, I told you about, you can use it for goods and services. For goods, there is a definition, section 2 clause J, trade and manufacture. And for services, there is a definition called 2Z, services, banking, communication, education, financing, insurance. So you understand that you can use trademark for anything, right? Services is something which is never ending. You can just imagine what services you have and you can use a trademark for that services. Goods, trade, and manufacturer. These are the two types of good that is even available in the world right now, right? Something are traded and something are manufactured, right? So you can use trademark for all. Understand, trademark never expires. You have a trademark, it is for you cannot, there is no expiration period. Like copyright has an expiration period of 60 years, patent has an expiration period of 20 years, but you don't have an expiration period of trademark. Why so? Because trademark gives you a right, like let's give an example of Microsoft. It is being used for so long, right? Let's take an example of Kodak. The Kodak company started in 1888. So trademark never expires. You have to only renew your trademark for after 10 years. That is what the need of trademark is. And why you need a trademark? As I told you, you need to communicate to people. Imagine McDonald doesn't have a trademark tomorrow. How they will communicate their quality, they will communicate their brand value, or they will communicate their product to other person. So trademark is very important for communicating your value, communicating a brand to other persons. Identification of yourself, right? You identify yourself with the trademark. You popularize yourself from internet and social media. You popularize yourself or with all those sorts of advertisement that is there, tangible and intangible, as well as undoubtedly trademark is a valuable asset to you. So this was the primary concept. Those who don't know about what is trademark, this was the primary concept of what is trademark. You can choose a trademark. That mark can be anything: label, drawing, photo, logo, anything, whatever you want. And that trademark can be used for any type of business, goods and services, and that business. And that trademark is different from what is branding is. So this was a trademark. This was a basic analysis of trademark. I hope this is very clear and there is no need for any other further clearance. So now we will move on to the types of trademark, right? So now trademark selection. Before you selecting a trademark for your business, you have to understand what are the types of trademark. What are the types of trademark in the existing types of trademark? See, There are lots and lots of trademark in the world. Even you are not able, we are not able to imagine how many trademarks can be there, right? So, but these are some of the important points. So, for a selection of a trademark, the first point is which type of trademark you are going to select. First one is word mark. Word mark is nothing but the actual word represents the trademark. The registration is for the word, right? Google, L'Oreal Paris, Oracle. These are the word marks which are used for the representation of only the word and nothing else. But this is very important. You have to understand there is no logo in that. There is, if there is a logo, it will come into another types of trademark. So when you are dealing with the word mark, only that word is coming into the existence, right? Now coming to the device mark. This is the logo. When you are having, you are attaching a logo onto that other than the word mark, then comes to the, it comes into the purview of device mark. That device mark, you can give, you can take the example of Bentley, Porsche, and this is, I think this is the trademark of Nike, Tata. You can see this logo or a specific mode or design of a name is called a device mark. A device mark include label, sticker, monogram, logo, or any geometrical figure. So when you are only dealing with the word, this is word mark. When you are dealing with the device mark, when you're dealing with the device mark, you are also including a logo in that, right? That is very important part. Understand device mark and word mark. Now this is color mark. You understand when you open Facebook for your for seeing your profile, you see there is one background color that is always there. This is a color mark. This is also registered, right? Cadbury has a registered color mark on that wallet, that purple color, right? So this color mark is also very important. Tomorrow, suppose, let's say I told you I will be let's say I will be opening a hotel chain that deals in burger, and I took my the burger this advertisement in the term of McDonald's, this color of McDonald's having an orange one, right? So that will be an infringement of a trademark, because color was also registered as a trademark. McDonald's has also registered its color as a trademark. So that is, has to be very importantly understand that this color mark is also very important for any company. There is also a case which I have written it down here, that Nestle also once in 2008, if I'm not wrong, Nestle in UK filed a case against Cadbury to use of its usage of purple color. It said that purple color is not distinctive and it should not be used by Cadbury. Well, Cadbury won the case because it was able to prove that all the evidences, it was able to prove that this color has been used by Cadbury from from I think 1915. So Cadbury is definitely has that market and has that known market value in the market, so that this color can, whenever we will see the color, it is definitely giving a glimpse of having a Cadbury, right? So that is an importance of a color, because from a color the people start understanding your brand. Like if you are trying to bring a chocolate of Cadbury, you will definitely understand that, okay, fine, this is the color of that or this is the color of that Cadbury purple color. It's definitely it's of that quality, it's of a Cadbury. So that is an important of a color mark, right? These are the one letter mark. Honda, Volkswagen, LG, these are the one letter mark. Nothing to understand in these. These are also creating, these are used for creating distinctiveness. And these are the shape marks, the second one, where shape is being used for acquiring distinctiveness. There comes a very important point where you have to understand that this shape mark in trademark is different from a design act. In intellectual property, we have design act also. In trademark also, the shape mark is also registered. So you have to understand there is a difference between the shape mark for trademark and shaping or designing in design act. When you are having a design, and if design is there having an aesthetic value in that design, you have to register it in the design act. But when your design starts giving the source of origin, giving example, when you catch when you see a Coca-Cola bottle, ultimately as soon as you will see the Coca-Cola bottle, you will definitely realize that, okay, this bottle is from Coca-Cola company. When you will see the chocolate that is designed of Kit Kat, you will definitely realize that, okay, this shape is belongs to Kit Kat, and that's why this has to be for a in this the source of origin is KitKat, right? So this is an important part you have to understand. This shape, when it is pointing out to a source of origin, then it will be registered under trademark. But when there is a design, so let's say this design is there, right? So when this design is there, this is nothing. But when this design is there, it is only beautifying it. You will go to design it. It is not declaring any source of origin, right? So when there is source of full funda, when there is source of origin, you are able to understand, this will be in trademark. When you are not able to understand source of origin, this will be in design act. You have to make it clear. This is very confusing. All people get confused in this shape mark. So now another type of trademark is certification mark. So when you are building a business, when you are having, so let's say you are dealing with an industrial product, when you attain some quality in that industrial product, a certification mark is being given to you. What is the certification mark? Is that this certifies your business, that your business have that value, have that quality, or have that product quality, right? So if you are having an industrial product where your industrial product have an ISI mark, ultimately what will happen is that whosoever will see that ISI mark will always see or will always distinguish your good of having a superior quality. This is what the use of certification mark is there. These all marks are certified in that sense, where people are able to distinguish your product in terms of quality. Certifying like BIS hallmark. This BIS hallmark is used for jewelry. Agmark is used for agricultural product. So these all mark are used for the purpose of certifying your quality of the product, right? So you have to understand certification means certifying your product to have that quality. Collective mark. Collective mark is very important to have, because if you are in an organization, right, let's say you are a member of CII, Confederation of Indian Industry, you can use that CII trademark as a part of your business also, that you are a member of that CII, like ICSC, Institute of Company Secretaries of India. If you're a member of this, you can use that logo of CS in your business. Like if you're a member of FICCI, you can use your logo in that FICCI. Why it is so? Because these collective mark are somewhat, they are all organizations that have attained some quality, or that have attained some standard in the world or in India, in the countrywide, and that countrywide standard, they replicate their countrywide standard by having a different logo. Okay, I am a member of ICSI. So that is what is known as collective mark. They are held by an organization. Now this is called as well-known mark. Well-known mark are something which is very important, and I think to my understanding, well-known mark are the maximum protected mark in the world, right? What is this well-known mark? This, the definition is given into section 2 clause ZZ, but I will try to make you very clear in simple word, that when you are having a mark which has gained substantial importance in the world without even registration in India. Suppose if some let's say if Mercedes had not didn't register in Japan, but still Mercedes has so substantial value, has so substantial interest, and has so well known in its field, that using Mercedes even for some other product and good will also lead to confusion to the public. Tomorrow, if I like, let's say I told you I will be starting a business of hotel. Tomorrow if I start using Mercedes logo in my business, and I claim that okay, Mercedes is for the car manufacturing, I will be using it for good, for food, then also I will be restrained from using the this mark, because Mercedes is so well known that it will definitely create confusion to the public. This is what is called as well known mark. Even today Apple doesn't register in all the countries. Even if Apple is only registered in America, still the using of Apple in Australia, even if there is no registration of Apple, will also be considered as it will also create confusion to the public, because that level of well known, or that level of substantial brand value it has attained, that it is so well known mark, that is called as well known mark, right? So I, to my understanding, they are the most highly protected marks in the world, right? So these are the point: well-known mark, certification mark, collective mark. Right? Now, most important point: selecting a trademark. When you are going for a selection of a trademark, you have to first of all decide where you are going, right? You are going either in word mark or a device mark, color mark, shape mark, one letter mark, right? All we have discussed right now. So before starting, you have to first of all make yourself very clear which mark are you going for. Don't think that you will be going for a certification collective well-known mark. You have to understand the difference between what I have written above and what I have written downwards, right here. That collective certification and well-known mark, you don't apply, you earn it. These are certification you earn by having that quality. You earn collective mark by having an custom with the with an organization. You earn well-known mark. You don't apply for these mark, right? You don't apply for collective certification or a well-known mark. What you have to apply is for a word, device, color, shape, or one letter mark, or there are substantial other marks. Even you won't imagine, if we have sound mark also. Nokia, when you used to start the old set of Nokia, there is a sound that used to come, right? So that is also registered. Samsung, you can listen the sound of Samsung. There is a unique sound of Samsung whenever you start a Samsung phone. That is also a phonetic, comes under the phonetic non-conventional trademark. That is also registered in that. And you won't imagine, even some perfume industries have registered their smell mark in that, right? So we can't even imagine to what extent trademark can be. But in a general sense, whenever you are starting a business, you have to first of all think these four, right? Four, sorry, these are five: word mark, device mark, color mark, shape mark, letter mark. Don't think about certification, collective, well-known mark. Now, after selecting, let's say you have selected that you will be going for a device mark or a logo mark. You have to see which mark are more important and which mark can provide me more security or more power, more strength. For this, you have to select a category of trademark, which is known as four types of category: fanciful, arbitrary, suggestive, and descriptive. Now, if I choose a descriptive, a logo, as I told you, now I have to choose my trademark in terms of these four categories. These four categories is not available. There are no law for that, but these four categories are basically used in the world to substantiate the strength of a trademark. Strength means how powerful your trademark can be, so that nobody can infringe your trademark, and how powerful a trademark can be so that people are easily available, or people can get easily attracted to a trademark. This is what is called as categorization of trademark in terms of the strength. Now, suppose, let's say I will go for a fanciful or arbitrary. So now you have chosen whether you will be going for word, device, shape, mark, color, whatever. Now come to the selection of category. Now, what are these four? You have to understand these four while selecting your trademark. Okay, so make yourself very clear. You have chosen one: device mark or a word mark. Now come to the strength of this trademark. Fanciful mark. These are the trademark which are made up of words having no prior meaning. You have to make it yourself very clear that there are no words which have no prior meaning. There are all words are there which have something or the other meaning in the world, right? But actually, when they have started their business, there was no substantial meaning of that word. Imagine having Kodak for a camera. There was no substantial meaning of Kodak when they started in 1888. That is called as fanciful. You cannot tell me nobody can tell me the okay, you have the meaning, you can tell me the meaning also, but there is very 99% people cannot tell me the meaning of Pepsi, right? What is Pepsi means? So these are all the marks that are used only for the purpose of business. These are born up marks. These are no, they don't have any prior meaning to that, right? And that's why having no prior meaning, or having no prior substantial meaning, make these marks a very strong mark, because Samsung, right? So these marks are essentially very important and very strongly protected because they don't have any prior meaning. They don't have any substantial usage of that meaning, right? So this is where the whole issue of fanciful marks comes. They enjoy the broader scope of protection. Xerox. So these are the, whenever you will go to for a photocopy machine, actually what is photocopy? But you will say, "Bhaiya, Xerox kar do." So that is what is important of these fanciful marks are there, right? So these are the fanciful marks. Now, arbitrary marks. These are the marks which are known, in the meanings are known, but they are used for those products or services which have no interconnection with that word. Apple is a fruit, right? But Apple is used for mobile phones. Gold Flake, it is a very famous cigarette company. Gold Flake means sone ki parat, like you are having a gold plated thing, but that is used for cigarette. Camel is a very famous brand of cigarette only. The camel is an animal, but you are using it for cigarette. So these are the arbitrary work where you are using the word which has no prior meaning associated with that goods and services, right? So this is where very important point come, that whenever you are taking any meaning, that whenever you're taking any word which have some meaning, but you are using that word for some other goods or services, that will come under the arbitrary mark. That is also very important, and they also enjoy very strong protection due to their distinctive character. You have to make it yourself very clear. Now comes suggestive mark. Suggestive mark is a mark that suggests the characteristics, right? So for example, what is when you are saying something, like when you say a word, that word comes to a mind as a suggestion, that does not describe, that suggests you ki, okay, this is the word, so this will be that product, that you are assuming that, right? Airbus. So you are assuming that there is something, okay, fine, there is something which is related to the air, but you are not able to understand whether it is defense, whether it is a home manufacturer, or whether it is a domestic airlines manufacturer. You cannot imagine that, right? You have to further imagine through the word. Only you are. This is not describing you, but only suggesting you that, okay, this is the point. Citibank suggesting that okay, there is a bank, but what kind of bank is there? We don't know. Microsoft, a suggestion, software for microcomputers. They don't describe it, but they are only suggesting it. Okay, fine, this is a suggestion, and a consumer has to use his own imagination and his own mindset to clarify as to what is the mark for. They are also good, but they don't provide that protection. Right, in today's world, they don't provide that protection, which protection can be availed by fanciful or arbitrary. Right. Now comes the last, descriptive. Descriptive was the least protected mark in the world. Right, it describe, example, KFC, Kentucky Fried Chicken. So ultimately, whenever somebody will see that Kentucky Fried Chicken, they don't have to even think of it. They will only imagine, okay, fine, this is chicken. They're selling fried chicken. Pizza Hut, only it is pizza, right? Cartoon Network. Cartoon Network is simple, describe. So they are describing. So consumer can't identify product. They can only say, okay, fine, this is by the name itself. The name says everything. This is called as descriptive, and that's why they are the least protected mark. We trademark lawyers don't suggest any people to go for a suggestive or a descriptive mark. We only go for fanciful or arbitrary marks so as to get a good protection while selecting a trademark. Right. There are also one more point. It is called as generic marks. Generic mark are it is impossible to register. I will give you an example. Like suppose tomorrow if I manufacture a medicine and name it paracetamol. These are generic words, right? Tomorrow I am manufacturing a wine and named it alcohol. These are generic words that is impossible to register. So that's why I have not dealt it. So you have to make yourself clear while selecting a trademark, you have to choose in these four categories: fanciful, arbitrary, suggestive, descriptive. Right. Now there is a lot of confusion while getting into suggestive and descriptive. There is no clear-cut distinction between suggestive and descriptive. Right. You should be clear. One funda: when you are able to imagine what is the product is, it is descriptive. But when you are not able to imagine, when you are you need to something, you need to put yourself into some pressure कि भाई क्या है ये, that is suggestive. Right. So you have to make yourself clear in this thread line. There is very confusion because even the courts are confused. You see, I have taken up an example of double mint, where European Court of Justice held that double mint for gum was merely descriptive and therefore not a valid trademark. But that trademark has already been registered in US. Ohim versus Wrigley case. So avoid using both. I will say avoid using even suggestive or descriptive. You have to, if you want to go for a very stronger protection, go for a fanciful or arbitrary. You can just choose um, your business, like your business is something for like there is also a company called banana, but that banana is a fruit, but that company deals with something I don't know exactly, but I think it is some industrial product. So that is what called as arbitrary marks. So these are very strong protection mark is there. And also avoid using a similar pronunciation. There's the famous case of Coca-Cola versus Clay in 1963, where the company was named as Coca-Cola, and the Coca-Cola filed a suit against that company because when you are pronouncing that Coca-Cola, it is similar to Coca-Cola, right? So we have to, while selecting a trademark, we have to be very much clear that okay, you have to go for a fanciful and a descriptive one, and don't go for a fanciful and arbitrary one, and don't go for a suggestive and a descriptive one, or neither go for a similar pronunciation one. This is the basic fundamental analysis of what you say about trademark selection. Till now, if anybody has any confusion or if somebody wants me to repeat it, please let me know.
Sir, we have received a question from Arun Bhapat.
Yeah.
He is asking that Colgate has also red. So, how can the colors be trademark?
See, the thing is that when you are trying to file a trademark, there is an option of claims, right? In claims, you have to register yourself as a red, right? That you are also putting up red in that in that claims, right? So when you are putting up the claims and when you have registered when you have a registered trademark of that claim being red, if any further company tomorrow Patanjali comes with a toothpaste having a red mark, it is an infringement of that. So what is he asking? What is intended to ask?
He's trying to ask because that like McDonald's has the red as a
No.
trademark.
The thing I told you. See, these are the goods and services. I told you goods and services. This distinguishing goods and services in a similar product line, right? So ultimately, tomorrow, I give you an example. Tomorrow, if I start in hotel industry having that McDonald, having that color of McDonald, that will be an infringement. The product and service, the whole soul of product and service has to be there in terms of where it has already been used. Like Cadbury, why Nestle does it? Because if you will see Nestle has also somewhat similar color to that, right? But tomorrow, if I start making a toothpaste with that Cadbury color, no infringement is intended to be. Your color
Okay.
represent your product and service. Yeah,
Okay, sir. So he want to ask you in a clear manner. So I am unmuting Arun Bajpa.
yeah, please.
Hello, Arun.
Hi.
Hi, you
Hi.
can
Yeah,
ask
please.
the
Yeah,
question.
yeah. Suppose if you have this red and white color scheme and color combination, in
Mhm.
Colgate, and if they change the color scheme, I mean, they get registered with the red and white color scheme and color combination or something, and get registered with that. And subsequently, if they use a different colors, then can an opposite party say that, look, these people have already changed the color scheme combination, so they cannot claim a right over red and white color scheme and color combination?
See, the thing is, first of all, I'm not able to understand whether you are asking in a similar business or in a different business.
Similar business, similar business. Suppose if you are
Similar
using
business, yes, definitely. Your question is very clear. If you are using in a similar business, and if that particular company has attained some goodwill in the market by that color. Remember, 1915, Cadbury has started its purple color, and 2008, Nestle has done an infringement. So, if that similar business is there and that previous company has attained some goodwill with that color, it can prove and it can have that suit for injunction or rather infringement. Clearly, no issues for that.
now here the question is, suppose if I have a business of toothpaste and
Yeah,
I'm using red and white color scheme and color combination on the test tube
yeah,
as well as the
yeah, yeah,
carton also.
yeah.
And if I register it, I got registration for both.
Hmm,
Subsequently,
hmm,
some other company or corporation,
hmm,
and then so not the same corporation, my own corporation, if they change the color scheme, red and white instead of red and white, we can say about green and white or any other combination.
hmm.
So can I lose my red and white color scheme combination
No,
back?
that very.
Because the opposite party tomorrow he will take a stand that, look, they themselves have changed it now.
No. I told you. I told you. I'm telling you. Have you ever seen Pepsi? Pepsi has changed around. I'm not sure about the number, but around 15 times the trademark. Even the color also. The issue of you have to see the Pepsi. Wait, I will tell you. This Pepsi, you can see this whole that white, blue, and this whole circle. They have changed with red, white already, right? You are having a red, white already. Now you are changing it to some other. You can definitely do unless your change of that color claim has an infringement to other trademark who has already registered with your changing color. You can do it. No issues for that. You can do it.
Okay, okay.
Yeah, you can do it.
Okay, thank you, Arun. Uh, so I have a second question from Dev Kripa. He's asking that if
Yeah.
I'm registering a company, under which
Hmm.
law should I register? It is under Company Act or a Trademark Act?
Pardon? Which you are registering a company.
Yeah.
So you will go to the company, is that right?
Okay, so
No, in trademark is the registration of a logo, not a company. Yeah, trademark is the registration of your, this is Xerox, like Pepsi. These are the logo where you are registering yourself in a trademark side. But if a corporation has to register itself, they have to go for the companies act, right? That is clear. That is not a doubtful question.
yes, sir. Uh, Puneet, want to ask you a question. So I am unmuting Puneet. Hello, Puneet. You can ask
Hello?
Please
question.
ask. Please ask.
Yeah. So, can I apply for Apple in another class? So,
No,
Apple is registered in various other
no, no,
classes.
no, 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 no. This is done. Let me tell you. Yes. Can you see the trademark? This is a well-known trademark.
Yeah.
Yeah. So you can see the case law I've written. Diamond Benz versus Haibo Hindustan. Right.
Mm-hmm.
What happened in this case is that an undergarment company used the logo of trademark of Mercedes for
Okay.
their company. So it was contended that even if you are using a Mercedes logo for an undergarment, having no connection with your the goods and service. Mercedes is a car manufacturing, right? And you are using it for undergarment. The main contention of the Haibo in this one was this only. So the court said that no, you cannot do it because they are all so important and they are all so well known in the field that even using it for some other goods and services will also lead to a point of infringement.
So if it's not a well-known trademark but a registered trademark under other classes, then can we do it?
No, that depends on the point that then you have to go for a nice classification and other classification arena in the world. There are all classifications of goods and services, whereby if any goods and services is there, like suppose let's say you are taking up a McDonald one, or let's say you are saying not so well known mark, right? So ultimately, there I will come to the prosecution when there is a publication of a trademark while registering, and that company can easily say, in spite of the fact that you have some other goods and services, that company can easily contend that you are using my trademark. So that is very difficult because that is why it is difficult is because of the fact that no other person wants you to use their trademark even for other business and other entities, right? That is the point of trademark opposition. So ultimately that doesn't happen in India, but in India सब चल रहा है, होता रहता है.
Okay, thank you.
Yeah.
Thank you, Puneet. Is there anyone want to ask any more question? Otherwise, we can go forward with the prosecution part and other. So I think there is no more questions from the
Okay.
audience.
So
So we
yeah.
can go forward.
Yeah, so the prosecution part is nothing but the Bayer Act. What is the procedure and what is the provision given in the Bayer Act is something which is under the prosecution, right? So examination, publication, opposition, registration, right? So these are all the main heads of the prosecution. First one is examination. Now, when you are filing, you have a trademark, you have chosen. Now selection is done. You have chosen a logo, and now you are going for a arbitrary mark, and now you're going for the filing of trademark. You went to the trademark office, not going, even online can be done. So you just went there, you are filing the trademark office. If there is any objection, an official examination report will be given to you within 3 to 6 months. In that official examination report, you will be getting into two refuse. You can get that report in terms of either refusal or objection. The two sections which deals with the refusal is section 9 and section 11. So ultimately, whether it is refused or it is objected will be dealt under these two sections only. Section 9 is an absolute ground for refusal. Why it is an absolute ground? As the name suggests, absolute ground prima facie rejects your trademark. Why? Because there are reasons that is given, like suppose if it is devoid of any distinctive character, it is consisting of any exclusivity of marks designate the kind, quality, intent, service, value, geographical origin. For example, tomorrow I started making a tea manufacturing company and I named it as Darjeeling tea. Darjeeling tea is a well-known geographical indication for a tea in Assam, right? So this is absolute ground of refusal. No, you cannot do it. You are using a mark or an indication which become customary in the current language or in the bona fide. You are using it in the trade. There is simple language that you are using in the trade. Absolute ground for refusal. These are the grounds: public confusion, matter, religious, scandalous, obscene matter. These are all points which is the absolute. Prima facie, your rejection will be there for your trademark. This is something which is very clear in terms of absolute ground. Now, section 11 deals with the relative ground. Why it is relative ground is because there are some scope left, at least. Absolute is something there is almost no scope left. I will deal it in another slide. But relative is there are much scope left for your trademark registration. The relative ground deals with an earlier trademark or having a similarity of good, which will cause a likelihood of confusion. There are some registered goods and services for which earlier trademark is not is registered. So you have to understand this. Absolute ground is a general reasons, but relative ground is mostly the reason of the registration of already previous trademark. Now, the question that was asked by a person right now about this Pepsi, this well-known trademark, that if it is not a well-known trademark, that trademark, even if it is not in that goods and services, that will be under this section 11 relative ground of refusal. Because in that relative ground of refusal, if it says its identity with an earlier trademark and similarity of goods and services, right? So that can be considered under the that rejection can be done under the earlier trademark, and person can be registered. A person can be can oppose that particular registration on the only on the basis that yes, your registration has an identical business, right? But to be very honest, there are the opposition. When you are dealing with the opposition proceeding, in maximum cases what happens is that this type of disputes, whenever there are disputes whereby an identity of a product is similar to the earlier trademark of the same business, they are absolutely rejected. But when they are not in same region, that comes to an opposition perspective. But right now there are very less chances where you can see a similar trademark for two different goods and services, right? So that's why this is generally avoided, because ultimately who knows when you will become famous, right? So this there is always a tendency that okay, even if your trademark is having some is for a goods and services similar to an earlier trademark, but not for the similar same class of business, it might be registered, but it is already avoided, as he was asking. So section 11 can be used for this case. One can interpret similarity of goods and services, but yeah, earlier trademark holds more value, right? Nobody wants to get their trademark for even for other goods and services, right? That will definitely cause this section 9 absolute ground. It is such a nature to deceive the public or cause confusion. So this will be whole sort of a debate in the trademark opposition, but that is a reason, a ground for a relative ground for refusal, right? So identical, similar good, not registered, or TRIM is prevented by law. What is the difference between section 9 and section 11? I told you, section 9 absolute ground, prima facie refuse to get itself registered, as compared to relative ground when there are some scope left actually. But if the mark has acquired some distinctiveness or significance, the mark can be registered even under the absolute ground. You have to make it very clear that even the official examination report reject your trademark under the under section 9 absolute ground, still you have a scope at least have to prove that yes, your mark, even if it is coming under section 9 of absolute ground, this mark has acquired some distinctiveness or significance. Like for example, let's say forget KFC. Let's say KFC is not registered in India, but still KFC being so common and being forget that it is a well-known trademark also. But if KFC start registering it in India, it can give that it has acquired some distinctiveness significance in the country, in the whole world, so that even section 9 absolute ground won't able to affect that trademark registration of that KFC. So you have to prove, even if you are coming under section 9, you have to prove that the mark has acquired some distinctiveness or significance, right? So now after the report, you get a report, the applicant need to reply with an appropriate reply within 1 month, right? You have to reply within 1 month. Two chances are there in this. But either the examination is satisfied by the reply and he will move on to the publication, and he is not satisfied. If he is not satisfied, he will list the application for hearing, giving date and time. That is a procedure that will be adopted. When he is not satisfied, he can call you and he can discuss with that. If he is satisfied by your appropriate reply, then it is going to publish in the Trademark General. Trademark General is officially available in the IPI India website of Trademark, official website. And in that Trademark General, it is always updated on Monday. So you can see, anybody can go in Trademark Generals and you can see all general or all trademark which is updated every Monday. Now here comes a very important point which requires a whole webinar of trademark opposition. Now when you are dealing with when your publication is done in Trademark General, now it is the process of opposition comes. Now if I am there where in Delhi and somebody is there in let's say Bangalore, I don't know which they are not well known even, so how can I know that the same mark is being used by them, right? So that person in Bangalore will see the Trademark General every week and will claim that okay, you are using this trademark, it is already my trademark, and there is an opposition claim. That is what is this is a point where you need a lawyer or a firm that is needed, and that is a huge area of prospect in trademark opposition, right? So you have to oppose it. There are all sort of opposition process, like you have to go for a notice, you have to go for counter statement, other counter statement, evidences. A very long process is there. Since it is only for prosecution, I will be restricting myself for prosecution. So this has to be filed within 4 months. So trademark opposition is always filed after the publication of trademark, in the publication of trademark general, right? So then it is an opposition. Finally, if there is no opposition, then the application will proceed to registration, and you will be granted trademark for 10 years, subject to renewal for every 10 years. So you have to understand this trademark examination. You examine it, you will get an official examination report. You can be rejected under section 9, 11. Otherwise, if not, application is successful, your application will go to for publication in trademark general. Your trademark general it will be published every Monday. After publication of this trademark journal, you can get an opposition. That opposition has to be filed within 4 months, whosoever is opposing it. That opposition is a very long process. If you are going into the opposition, that can take up to 2 years time, because then it will go to the registrar, and then registrar, if you are not anybody who there is a very less chances where everybody is convinced by the decision of registrar, then you will have to go to IPAB, Intellectual Property Appellate Board. This is the whole process. That's why I told this is a very long process of trademark prosecution. So ultimately, when you come succeeded after opposition, or rather you are not opposed, then it will move for the registration. This is the simple, basic, fundamental understanding of what is trademark prosecution as a now in India is concerned. Now, I think these are the prosecution, and this was the selection. Now, I think Neelam, if anybody has any question for this, you can let me know. Because I think ahead of this, prosecution is infringement, which is almost outside the scope of this webinar. Infringement, then it is something you can say opposition, infringement, registration, or other factors. So for prosecution purpose, I think this is enough.
Okay, sir. Thank you.
Please let me.
So for the opposition and infringement, we can arrange some other way. So if the attendees are interested. So I have a question that if a company or a person is working on some particular thing, like someone is selling sweets from last 50 years, but the sweets are so popular in the place of throughout the state or in the country that some other person are copying their products, like their name of the shop, to sell the products, but the product has not been copyrighted. So it has not been trademarked. So can we trademark the product?
Okay, so this is, I wanted to also deal with this. It is a very interesting topic. See, first of all, you don't need to register trademark. This is that trademark can be registered and cannot be registered. Even if McDonald, imagine, even if McDonald is not registered, still it have all the rights which a trademark registration have, right? So if that sweet shop is having 50 years, you said 50 years or something like that, and even if it is not registered a trademark sweet shop, still if anybody is using it, that particular sweet shop can claim an infringement, because that sweet shop has gained some excellent distinctiveness in the market. You don't need to register. You can also go to court without even registering, right? That is I wanted to deal this, but since less time, there was less time, so I thought not to deal with this. You don't need to register trademark. There are okay, fine. Trademark infringement and trademark passing off. There are two perspectives of in Trademarks Act, that is called as trademark infringement and trademark passing off. Now, when you have registered trademark, you will go under the trademark infringement. But when you are not registered trademark, you will go under trademark passing off. In passing off, what is the claim is, what is written in this trademark act is that even if you have not registered a trademark, you still get the protection because of your inherent distinctiveness that you have created in the market, right? So that sweet shop, even if not registered, can easily claim it. No issues for having a registration. Neelam.
Okay, sir. Thank you. So the questions from Aishwarya Bhatt. They want to ask, in case a similar trademark has not been noticed in the publication and we find it out later, can we still go to court and get the other party?
Please repeat. Please repeat. Yeah, please.
In case a similar trademark has
Hmm.
been noticed in the publication and it was after 4 months, and it was found that it has been, we can still go to court that other party has, the parties, the trademark.
See, the thing is, yeah. The thing is the date, the timeline that is given is 4 months, right? After 4 month, probably yes, you can go, but then you have to prove, and then you have to tell the court that why, what was the reason why was you were not able to go for why you were not able to that give the letter for opposition within 4 months. So probably it is better to go within 4 months, but then if you can go, no issues for that, but you have to prove that there was some substantial reason why I was not able to get into that 4 month time period.
Okay, that means the 2 months of period is not,
4 month, 4 month.
okay, sorry. It was 4 months, and the 4 month period is, we can explain the code that, why the 4 month we have not in the court, but we have not filed any case till this 4 months.
The reason has to be given,
Okay, sir.
but that is close to very impossible, because then only ultimately every company who is having a registered trademark and who are doing a good work in this trademark area, they are very active, and it is highly impossible to think that they will not be getting that similar trademark in this 4 month period.
So from many,
I don't think that there is a this loss.
okay, so from many years, like, because trademark and the IP law is coming in now in this last 2 to 3 years. But previously, those general companies or general startups are not taking this trademark or copyright very seriously. So if, like in some places, a particular place, the person is working with his sweet stall or some other thing, but it became popular at a certain, and now people are copying their products, then obviously he can go to the court even after 4 months.
Uh, can you repeat what you are asking? What you're trying to ask? Please repeat.
Uh,
What you are, what is the focus, right?
okay. I know a sweet stall, and it was around 50 years, like more than 50 years, because the sweet stall was established by the owner's grandfather, and then his father took up the shop, and then he also took up the shop. But from his father's period, they started low. The shop was so popular that other people also copied their name of the shop and started selling sweets on their name. And they have to put that original on the front of their name, so that people will know that it's original and others are doing duplicate. But if now they will come to know about that, okay, there is something called trademark and we can go to the court. So it has been more than four.
Awareness of law.
Yeah.
Awareness of law. You are saying that okay, fine. Afterward, when they came to know that okay, fine, we have a trademark. So awareness of law is something which is of no ignorance of law is no excuse, right? So they can go for a trademark registration anytime they want. But yes, if they are having sweet shop and if they have not registered, I told you there is a passing off. In that passing off, they can go to the court. Then they can claim that this is our trademark. They have to prove it. If they are able to prove it, that yes, this is my trademark and this is something which I have earned it and we are working for last 50 years, court can easily give you the decision that yes, this trademark, since it belongs to you, it has created a lot of effect on the market. You yourself is eligible to work for that, and you yourself is eligible to work, to use that trademark. And after that, undoubtedly, no issues. The court can also provide an injunction to all the people who are using the trademark. You don't need to even in passing off also, right? I told you, even in passing off also, you can go to the court and you can claim, but you have to prove that there is some goodwill that is attached to your trademark. That is a very important, and that is very difficult to prove in the court, that you have using this goodwill. There is a goodwill. You cannot bring all people of that city or state to say that see, these all people know me. That goodwill has to be proved, and if it is once it is proved, you will get your right, even if you are not registered trademark. And even the court can give you the injunction to all the people to stop using that trademark from further use. They can do it, no issues with that. Passing
Okay,
off.
sir. Thank you. Okay, sir.
We can. This is a very huge topic. We can also put up this webinar on passing off only. Passing off infringement and opposition. This is very interesting topic also, and some other day.
Okay, sir. So, I will talk up 2-3 questions quickly because we are running out of time. So, I will mute Arun to ask his question.
Hello. Hello.
Hello. Yeah.
Can you give us what is the expungement of trademark and when that expungement takes place? Under what eventuality?
Ex.
That is number one. And number
Pardon,
two is
Mr.
that can you just display some landmark Supreme Court judgments on trademarks with citation? Only landmarks, few, so that we can
No,
read and
no. The thing is
understand.
that One thing that I know
Two things.
some of the
One,
landmark.
yeah.
Let me finish. This landmark judgment, I was knowing it, but I didn't put it up because this topic was so huge. So right now, I don't remember any such landmark judgments right now. I have the list. You can connect me. I have that list of all the landmark judgment. Through mail, we can connect it out. This landmark judgment, I can give it to you there because right now I don't have that list of all landmark judgment right now with me. And regarding your second question, I'm not able to understand what is this expunge. What you said? Expungement.
Expungement made of trademark. Expunge. You are expunging, no?
Can you give
Expunging the trademark.
Can you give an example for that?
In passing off, when you get registered.
Can you give an example for
after,
that, right? So that I can understand?
I mean, removal from the register. It's
Revolt?
called expungement, no?
Yeah,
From the register, trademark register.
So what you are asking, you cannot, even if you're not
under
registered.
what eventuality it can take place, expungement?
See, even if I am starting a business, I don't think that even I don't need to require a registration for a trademark. So this expungement can take place at any time, at any point of time.
Now, what is required to be proved for that?
Goodwill. I told you that is very important. This is goodwill. That is very important because if I am using my trademark for, let's say, if I am a very famous suit shop in a city, and if I have not registered trademark and then I went to the court for a passing off, then the most important point you have to prove is that you have created a goodwill in that market, and that goodwill is very important. I think it is not easy to let the court believe your goodwill. And secondly, you can have to prove that you have as separate in distinctiveness that you have created in the market. So these are the 2 points that it has to be proved in the court for passing off. If you have registered trademark, no issues. You don't have to prove any goodwill or anything.
And every 10 years we have to renew it, correct?
Trademark is for lifetime. You have to just renew for 10 years.
And if you fail to renew, then are there any consequences?
Yes, there is a consequences. There will be an issue of notice that will be put up on the website when you will search your trademark, that not renewed. And after a substantial period of time, I think it is around 1 year or so, your trademark will be there in the public domain.
That will be removed.
Public domain. It will be. I can use. Even Tata is there. Even if Tata failed to renew it, and even after subsequent notice from the registry, they have not renewed it. Even I can use Tata tomorrow.
Oh, is it so?
That is very important because that's why trademark is very hot topic these days. I'm sorry, Arunji, I'm sorry, I'm not able to give you the landmark judgment, but yeah, I can just give you my mail ID where
you can forward to Lawseco. We can get it from. You can forward to Lawseco. We can get it from them.
Yeah, I will forward it to Lawseco. But I will also make my mail ID so that
because these are very cardinal principles which are laid down now. So that would be better that if we can go through with that to understand in depth. Because what you have given us a very good explanation and nicely arranged, the way you
actually,
have.
Arunji, I understand the judgments are there. I understand, but actually, when I was discussing with the topic with Neelam, I told her that this selection and prosecution, if I started dealing only with selection, if I going into deep of what are the intricacies of selection, it will only take 2 hours time, right? So I have to finish everything, trademark selection as well as prosecution. So that's why I refrain from giving any judgment, because when I start giving judgment, I need to also give the court contention, right? What was the contention by the parties, right? So that was very important. I will forward it, no issues for that. I'll forward it to all, to Roscoe.
Okay, thank you.
Thank you very much. Thank you.
Thank you, Arun. So another question is from Krishna Priya. I am unmuting her. So hi, Krishna Priya. You can ask question to sir. Hello.
I'm not able to hear her.
Yeah.
She can write it down if she wants.
Okay. I'm reading out her question. Maybe she's unable to speak. Uh, Sorry, Krishnapriya, you are not audible. You are not audible.
She said, please ask the question.
Okay.
No, she can write it down also. No issues.
Okay. I'm asking. Her question is, considering there are a lot of applications filed on a daily basis, how is it practically possible for a lawyer to keep track of all publication to see if a particular trademark infringes their client's trademark?
That is what lawyers took money off, right? So that is what thing is practically possible. That is the reason why we work till late nights. Practical reason, that is what we take money off. So that is only the practical reason, right? It is no issues, nothing else. It's just that we have to keep every day updated. We have to go to IPI India side every day, especially every Monday, to see other clients if there is any new trademark and whether that new trademark has taken our client trademark or not. So it's nothing, no hi-fi rule, only just to keep updated. We have to go every day to IPI India website and just see and be updated.
Thank you, sir. Sir, it is once I was reading a post in LinkedIn. It was written that we lawyers don't, we owe you for, you owe us for the life because we update ourselves every day. You don't owe
Yeah.
us for some minutes or seconds.
Yeah, I think she told how
Definitely say.
how do they go about it. Krishna Priya, it is nothing. There is no. I told you this. There is no hi-fi rules. Every morning, just see, or every evening, just see this IPI India website. There you will see trademark journal. Every time you just keep yourself updated. This is what the thing has to be done. I don't feel any other reasons or any other point whereby we can keep ourselves updated without even going to the websites. So just go to the website and regularly keep ourselves updated to keep track of it. That is the only reason I feel. Well, if you have some other reasons, please let me know.
Okay, sir. Thank you so much. I think there is another question. Okay, thank you, sir. So,
Thank you,
sir,
sir.
end of the session, we have taken a lot of
Thank
time.
you.
So we will have another session with you, and I will request all the attendees to join us again for this trademark
Yeah,
passing of session. And
opposition and infringement I will be doing.
yeah, uh, still, since they have asked us to send your email ID, and so I'm sending your details on the chat box. You all can connect sir and also me on LinkedIn. We will be pleased to help you out. And through on behalf of Losico, it is an request for to all of you to check out the website of Losico. There are free career assessment tests that they will help you with deciding your career after 5 years of law school. And also you can check the other links of the courses, the Law Eco Diploma IP courses, and also in courses of 3 months with Texas A&M University. That is a highly reputed university of which is ranked around 8 or 9 in the world for teaching IP law specialist. So you can check out. I'm sending you the link. Okay, sir. Thank you, sir,
Thank
for
you very much. Thank you.
yeah, and all the attendees to be here, and you have spent the precious time with us. So thank you all.
Thank you. Thank you very much. Thank you.
If anyone, you can rate the station from 1 to 10. So it was a great session. So let's let's leave. We have to leave the session because we have in short of time and other webinars are going to be conducted. It
Yeah.
was rated as 10 out of 10 by Arpita. Thank you, Arpita, for giving us your valuable time. So thank you, sir. We're
Thank you,
signing.
sir. Thank you. Thank you. Thank you very much. Thank you.